Senior Advocate Sanjay Hegde on the very important verdict that has just come from the Supreme Court. The court has upheld not only the constitutional validity of Section 6A, but the majority verdict read out by Justice Suryakant has also flagged that the implementation of the detection and deportation mechanism for illegal immigrants is not being done properly. Hegde sir, if we can get a perspective from you, what does this really mean now? With the court saying that they will be monitoring the implementation of the Salman Khan judgment?
Well, it remains to be seen as to how what mechanisms the court will be putting into place for monitoring the judgment. The Sarbananda Sonowal judgment had struck down the IMDT Act. This judgment now upholds the Section 6A of the Citizenship Act, in as much as everybody who can show that they came in before a particular date in 1971 are legally citizens of India. The question is, what happens to those who cannot prove it? Do they automatically become citizens of another country? Especially if the other country says that they are not our citizens, they are not born on our territory, and there is no place to deport them. So the actual working of this, only time will tell, and it will also be the nature of the mechanisms that the governments then put in place. There has been a separate judgment of the Supreme Court by a bench of Justice Vikramnath and Justice Amanullah, which said that you can't simply ipso facto presume that somebody who cannot prove that he's an Indian citizen is automatically a foreigner. That you have to have specific reasons. So
that
all
is
these
where the question comes in.
Will have to be harmonized.
So that is where the question comes in. Will the NRC process now, what impact does this judgment really have on the NRC process that is happening? That was also under challenge before the court. That was also under monitoring by the Supreme Court. We also have the question of how the entire process in Assam will go on now, because the court has said specifically that your current mechanisms are not being implemented properly, that you must do the job of identification and deportation. So how does this then, if we can get a sense of how does this then impact this entire question of the NRC and the political issues that had risen because of that?
I cannot address the politics of the issue. Okay, as far as the law is concerned, the NRC was a particular process which was mandated. And it was not the NRC that was mandated, but it was an updating of an NRC of 1951, which was mandated by the Supreme Court. The Supreme Court had then said that, look, there is a list which was made in 1951 as to who were citizens then. If you can prove your linkage to people on that list, then automatically your citizenship is sort of assured. It did not really deal with the question of what happened to those who could not prove a linkage with the old 1951 list. There are
so
several
are we then
other
looking at
questions
some mechanism that will have to be then created with regard to updating those NRC lists to ensure that people who came before 1971, before 24th March 1971 can be accommodated, especially since the court has said very clearly that anyone who entered before 1966 1st January is deemed an Indian citizen under Section 6.
Yes. Now, not only 1966, but even 71. Because those who entered in between 66 and 71 were to be disenfranchised for a period of 10 years. Now, that period of 10 years has more or less long gone. It is the children of those people and the grandchildren of those people who are now at issue. The real problem will arise in the case of those who can't prove that they were here before 1971. Will your neighboring country accept them? Can you render such people stateless? So those questions will possibly have to be answered one day, not only by the courts, but by Parliament and the legislature.
All right. And just as a last question, sir, if we can ask you to sort of summarize and simplify the reasonings that the court has given. They've, of course, said that Section 6A is constitutionally valid. They have said that anybody who entered before 1966 is a valid citizen. Anybody who entered before March 1971 can apply for citizenship. But anyone who entered after 25th of March 1971 is in fact an illegal immigrant as far as the Section 6A procedures are concerned. That is, in summary, what Justice Suryakant's reading of the majority judgment seems to mean. Is that correct?
Yes, that is correct, substantially correct. But the impact of all these findings will still have to be worked out. Now, supposing you cannot get citizenship under the 6A rules, but there are other factors which tend towards the finding that you are a citizen, then those factors are open. And particularly when 1971 is over 50 years ago, life has moved on.
Thank you very much, sir, for explaining all of this. Speaking to Senior Advocate Vijay Hansaria on this major verdict that has come from the Supreme Court, the court has upheld the validity of Section 6A of the Citizenship Act, but at the same time has said that the state government and the center must take strict action against the illegal immigrants who entered after 1971. At the same time, the court has said you cannot choose your neighbors. Fraternity is a very important aspect of our constitutional ethos. Hansaria, so what does this judgment really mean now for Assam, for the people of Assam?
Well, it's a disappointing judgment according to me, because though the court has upheld it, it has recognized that Assam was discriminated. It was a serious issue. The illegal immigrants came from Pakistan, not from Bangladesh. Bangladesh was not born on the cutoff date of 25th March 1971. It was a part of Pakistan. And people from Pakistan, which is not a friendly country, had come not only to Assam, it has come to West Bengal, Meghalaya, Tripura, Mizoram, and came in large numbers. But only people coming to Assam have been given citizenship. So it gives a boost to the people who have gone to Meghalaya or the neighboring state to come to Assam and claim citizenship. Why this discrimination with the people of Assam? It has not been explained according to me. Whatever judgment I have read, I have heard.
But sir, the court has specifically said that the differentiation between Assam and the other states was valid. They have upheld that, saying that there was an intelligible criteria.
The court has said it has affected more Assam. If it has affected more brutally Assam, then why upheld it? It should have been other way around. If it has affected me more,
but they have specifically said the bench had specifically upheld the validity. They have said that those who came in before 24th March 1971 are not illegals. In fact, those who came in before 1966 are valid Indian citizens. Those who came between 66 and 71 can apply for citizenship. So, since you represent the Assam Sammilit Mahasangh, you had opposed the validity of Section 6A. How do you and your clients see this entire move by the court?
See, again, after 70 years, it is 71. No, nothing is, those persons have died, and then next generation, and 2 generations down the line. To say that they must be deported is just a paper advice, according to me. I'm sorry to use that word, but then nothing is going to happen on the ground. The court has to realize that after 70 years, can you deport a third generation people whose parents have become a citizen, but now you say 3 generations down the line has not become a citizen and they must be thrown out? How is it possible? Not even a single person. Let me tell you before you that not even one single person would be deported in the line of the Supreme Court directions, which is very clear to me.
All right. And so
that's why one more
also
thing,
with regard to
Justice Partyawala added, and rightly so, that it may have been right if you have deported, given a window of 1 year, 2 year, all right. People have come from fraternity within 71 to 73, but you can't have 50 years and 60 years go down and then say and give them all that they have to say they come before 71. What is there to show? That's all. It's very unfortunate.
All right. If I can also get your perspective on one small thing, sir, what does this mean then for the NRC exercise that was carried out on Supreme Court orders and the entire politics of Assam that came about because of that? Could you give us a perspective of what will this mean for that?
To use the word, I am very shocked that all Assam Students Union supported 6A. All Assam Students Union spearheaded the movement that illegal foreigners must be deported from Assam. And those, that was in 80s.
But sir, the court has specifically said that the Assam Accord, and which is the reason for creating 6A, came after a lot of political debate, a lot of the movement in Assam. And the 6A specifically gives implementation to what the Assam Accords had said.
I agree that 6A was in line of Assam Accord, but actually Assam Accord had so many things. One of the things was, all right, we'll give citizenship, but 9 other things we will take A, B, C, D action. Nothing has been done. So you give citizenship to 50 lakh people in Assam. In 1971, population of Assam should be around 2 crores. So on 2 crore people, you impose 50 lakh people and talk of humanitarian grounds, fraternity, only for the people of Assam. Why not in the other parts of the country? That was one of our contention ultimately. Why should Assam alone have the, and I don't see any answer on that aspect by the court unless I read the judgment. I cannot say more than that.
Thank you very much, Mr. Hansaria, for speaking to us and giving us this perspective. On behalf, you were appearing for the Assam Sammilit Mahasam. Thank you. We're speaking to senior advocate and politician, Mr. Salman Khurshid, on the issue of the verdict that has come from the Apex Court on the Section 6A Citizenship Act question. So the court has made some very important points. First of all, of course, they have upheld Section 6A validity. They have said that fraternity is a very important aspect of the constitutional ethos. But at the same time, those who entered after 25th March 1971 have been declared illegal, and the center and state have been asked to ensure implementation of identification and deportation of those persons. How do you see this verdict, sir? And your clients had been talking about this issue because it's also a political issue in Assam.
Well, this is all the consequence of a political issue. We must be, and I think the court was clear in this, particularly the Chief Justice made it very clear. There was a political solution that was found by governments of that time and the protesting students. And that political solution was the Assam Accord. But the legislative solution, i.e. the Assam Accord, reflected in the law that was made is Section 6A. So this is part of a larger solution. The distinction that had been made was, and this is obviously part of the political understanding, that those who'd arrived before 66, there was no issue. They would be treated as citizens, and that was more than fair. Now, the question was, the cutoff date of 66 is different from the cutoff date for citizens in the Constitution. And that was the contest before the Supreme Court. But in the circumstances in which the accord had come, the Supreme Court has upheld 6A. The second group was the ones that had come between 66 and 71, who were deprived of electoral rights for 10 years. And that, again, was part of the overall settlement to make sure that the sentiments of the protesting students were taken care of. And that now, of course, is also over because 10 years have passed long ago. So they also then become citizens. There was never an intent to keep anybody beyond 71. And obviously, anyone who's come beyond 71, they will not be citizens. And the cutoff dates were critical. 71, the cutoff date was critical because 71 was when the war happened and Bangladesh was born. So once Bangladesh is born, there is no further reason why anyone should be accommodated.
So, if for both a legal and political perspective, what does this now mean for Assam, for the people of Assam?
Well, this means what the people of Assam have accepted in the accord, and they've obviously lived with the accord for all these years, except for a fringe or a margin groups that have said, no, we must continue to fight and so on, and we must reverse the accord. So now, with so much water having flown down the river, as it were, it would obviously is a matter that you can't put the clock back. And people will therefore, anyone who would be instigated to say we will get the Supreme Court to reverse it would now be reassured that now whatever we decided at the time of the accord, that now stays for good times to come. And of course, the court has very clearly said that we must be vigilant about what happens with any influx beyond 71, even now, for instance. There we must be very tough and we must ensure that there is no influx and that there is no illegal migration. That the court has made very clear. So nobody can have any issue with that at all.
All right. So just one quick question. What is, in the terms of that, the entire political question that had come with regard to the NRC, what impact does this verdict now have on those questions which were raised with regard to the people who either could not prove their citizenship and in terms of the NRC exercise, and or those persons who could not prove that their ancestors had come or could come? What does this mean? Does this have any impact on that question?
Frankly, nothing was read out because the entire judgments can't be read out. The honorable judges read out substantial parts of their respective judgments, but nothing about the NRC was said. And the NRC really is something that goes beyond 1971. So the issue of NRC and CAA, which was a burning issue, that will have to be dealt with completely separately from this. But obviously, contextually, this is what would have the markers very clearly for them. The problem there in the NRC is not a problem of these people being beyond 71. The problem there is that all the people who've come beyond 71, there is a further categorization in the NRC and CAA of what is their ethnic background. So a distinction is being made for some people there by being put in separate category. Now that's a separate issue. That obviously would be a challenge that the Supreme Court will deal with. Yeah.
Thank you very much, Mr. Khurshid, for explaining this entire nuance of the matter.